Hello, I'm Adam Keelick, the principal attorney at the Keelick Law Firm in Bedford, Texas, where I help clients with employment law issues, as well as family law and personal injury issues. Today's short video is about when employees are owed overtime. And we'll talk a little bit about the laws that govern minimum wage and overtime in Texas. We'll talk about how overtime is calculated, how and when employers have to pay overtime, and some of the problems that employees run into getting paid the overtime that they're due. Here in Texas, wages, including overtime, are going to be covered by 2, possibly 3 levels of law. The primary law that we look at is the federal law, which is the Fair Labor Standards Act. That's what sets minimum wage and overtime minimums in Texas as well as the rest of the country. In Texas, our state-level law is the Texas Payday Law. Now, the Texas Payday Law defers to the Fair Labor Standards Act for most issues involving wage calculations. And so from that standpoint, whenever we look at what the state law provides, we're going to really look at what the Fair Labor Standard Act requires and go from there. The third level that may apply in some areas is a local law that could set a higher minimum wage than the federal law sets. I'm not familiar with any local laws in Texas at this point that set a higher minimum wage, but looking at what's occurring over the country, that may be something that changes over the next few years. So if we circle back over to the Fair Labor Standards Act, and because of the ways that the laws work here in Texas, we'll really just talk about that FLSA standard. The Fair Labor Standards Act says that there are employees who are exempt from the overtime provisions and employees who are non-exempt. And these are terms that most employees are familiar with, usually from the standpoint of whether an employee is salaried or hourly. Now, that's not really perfectly in line with exempt versus non-exempt, but it's at least a starting point that we can jump off of. The Fair Labor Standards Act sets a number of ways an employee could be exempt from the overtime requirements, and employees who meet the salaried exemption are certainly the most common under the Fair Labor Standards Act. And so by operation of those numbers, those are the employees people are most common to think about when it comes to being exempt from overtime pay. If an employee is non-exempt because an employee does not meet any of the exemptions in the law and they are governed by the Fair Labor Standards Act, then they are entitled to overtime pay based upon the calculation provided in the Fair Labor Standards Act. So let's talk about what that calculation is and how that works. Under the Fair Labor Standards Act, a non-exempt employee must be paid 1.5 times their regular rate of pay for each for each hour of work over 40 within a work week. And there's a lot of small components that go into that rule that are each by themselves very important. Now, before we get into that, I will point out that there is one very obscure but important exemption in which non-exempt employees are paid a different minimum overtime rate under the Fair Labor Standards Act. And this applies to employees who are paid on a fluctuating work week, or what is sometimes also called a non-exempt salary. These are employees who are paid on a salaried basis but do not meet the salaried exemption, and so they're still entitled to overtime pay under the Fair Labor Standards Act. But what makes it unusual for these employees is that they're not paid 1.5 times their regular rate of pay. For each hour over 40 worked in a week, those employees who are paid on a fluctuating work week are only paid the additional half times their regular rate of pay. So for example, an employee who works a fluctuating work week whose regular rate of pay calculates to $10 an hour only makes $5 an hour for each hour of work over 40 within the work week. And the reason why they're able to be paid that way, the way the Fair Labor Standards Act constructs that, is that the employee has already been paid on a sort of a non-hourly basis, and this is basically a premium on top of it for the employee working above 40 hours. And if that still doesn't make sense to you, just trust that this is the way the law works, and we just have to deal with the law the way it's written. But the number of employees who are actually paid on a fluctuating work week is a very small number. So let's go back and talk about what applies to most hourly non-exempt employees. And that's being paid 1.5 times your regular rate of pay for each hour of work over 40 within a work week. And unpack each of those issues, the small pieces of that rule, and how they play into the larger rule. So the first part we get is the 1.5 times. So that means that unlike those fluctuating work week employees, if you're paid $10 an hour for overtime pay, you have to be paid $15 per hour for each hour worked over 40 within the work week. The employer can't undercut that number. They could pay you more than that if they wanted to, but they have to pay at least that minimum 1.5 times. The real key here is calculating the regular rate of pay. And this is a complicated issue. It really goes beyond the subject of this video because we could spend a lot of time talking about some of the small issues that go into that calculation. But generally, for the regular rate of pay, the employer has to calculate your base hourly rate. And if you're paid certain kinds of bonuses, but not all bonuses, or commissions, or sales, or any other kind of compensation above and beyond your hourly rate, sometimes that is calculated into your regular rate of pay. But at a minimum, it's going to be your base hourly rate and maybe some additional pay on top of it. These calculations can get complicated when commissions or bonuses are paid out on a quarterly or semi-annual or annual basis, because we've got to go back and break it back down across each of those work weeks. And again, this gets into a really technical nuance about this rule. But for now, at least recognize that that regular rate of pay is your hourly base rate and could include some other issues. They can't calculate your regular rate of pay or calculate overtime against minimum wage unless that is your regular rate of pay or some amount that's less than what you normally earn per hour. That's a way that sometimes employers try to skirt overtime rules is, say you normally are paid $10 an hour, but for hours worked over 40, they may try to say that your rate of pay is $8, so that 1.5 times that is $12 rather than the $15 per hour you should get for overtime pay. So now we know what the overtime rate should be. Now we need to talk about how we know what work it applies to. And the Fair Labor Standards Act says you pay the overtime rate on each hour of work that's worked over 40 in a work week. So that means that whatever the employer's normal breakdown for pay, if they pay to the minute or 15 minutes or whatever, that's got to be calculated the same way for overtime. They can't use a less beneficial calculation to determine your work time for overtime than they use for your regular work. So if they normally bill, as sometimes employers will and round you up to 15 minutes to make it easier for payroll, they've got to do the same thing for overtime. They can't suddenly start billing you or calculating your work time down to the minute. And the overtime pay has to begin the second or perhaps the minute you hit over 40 hours within a work week. And this is an important part of the rule, too, that employers often try to short or work around to avoid overtime pay. And that's the idea of what the work week is. The work week is a 7-day period that starts on one day of the week and ends on whatever 7 days out from that is. So you could have a work week that is Sunday through Saturday. It could be Saturday through Friday. It could be Wednesday through Tuesday. Whatever the employer sets, it doesn't matter. It has to be a contiguous 7-day period. The employer can't calculate the work week on Saturday one week and then Monday the next week and maybe Wednesday after that and then go back to Saturday. It has to be a stable work week that is continuous, that is the same week in and week out. Now, sometimes employers do change their payroll practices and they'll move from one work week schedule to another based upon how the workflow is or their payroll vendor's preferences. But these should be a once in a blue moon kind of change. If this is happening every week, every month, every quarter, whatever, that's too frequent. That suggests that payroll is doing something to try to avoid overtime pay or some other kind of benefit or pay that employees are owed. There has to be some consistency to that schedule. It's also important to point out that it is a work week. It is 7 days. It is 7 continuous days. Sometimes employers will try to calculate overtime on a 15-day or a 2-week or a 30-day schedule. That way, if you normally work, say, 60 hours the first week of the month, and then you work 40 hours the other weeks, or maybe 35 hours the other weeks in the month because of the way the employer's workflow is, some employers will try to merge those weeks together so that that additional 20 hours of overtime you worked that first week is broken out into those other weeks, and by way of dumping 5 of those hours onto the next 3 weeks, they really only pay 5 hours of overtime. That's incorrect. Each work week stands as its own week for calculating overtime pay. This is a huge problem, and I see this quite a bit actually, especially in employers that work in shipping or transportation or various kinds of warehouse work, where they'll try to shift around those hours and like pay out on a 2-week basis. That's not okay. That's not legal. The employer can pay paychecks every 2 weeks, but they cannot calculate the work week on a 2-week period. The pay period and the work week are 2 entirely different things. And one last point about that rule is that if overtime is worked, if you work over 40 hours in a work week, you have to be paid the overtime pay for that time. Your employer cannot substitute out some other benefit or compensation in lieu of overtime pay. That means they can't give you comp time to give you vacation time on some other week. They can't roll off time off another schedule and shift those hours to another week. Now, the exception there is government employees can and do earn comp time instead of overtime pay, and that's fine. The Fair Labor Standards Act says for government employees, they can work comp, or they can accrue comp time instead of overtime pay. Okay, but if you work at a private employer, if you work anywhere outside of government, you cannot be paid by way of comp time for your overtime work. And if you're unfamiliar with this idea of comp time, it basically means if you work 45 hours this week, the employer will pay you 40 hours and bank 5 hours for you. So maybe in a couple of weeks, you want to leave early on Friday, you can leave 5 hours early and they'll apply the comp time from the week you worked 45 hours onto the week you worked 35 hours, so you have a consistent 40-hour paycheck each week. It's not a bad scheme, but with government employees, there's some protections there that allow the employee to go after the government in a way that an employee of a private employer really can't. And the concern is that employers will use this comp time strategy, or private employers will use this strategy as a way of basically getting employees to work for free on overtime hours and then never pay out that comp time or never allow them to take that comp time. And when that happens, it's effectively a lost wage to the employee. And if the employer has this policy of using comp time instead of overtime, those employees may not have a choice to elect the overtime. they may just be stuck working for free, and that's not okay. So private employers, no comp time, government employees, it's okay. So we've talked about how to calculate that overtime. We've talked a little bit in these issues about when and how overtime has to be paid, that it has to be calculated on that individual work week, no matter what the employer's pay period schedule is. And this is kind of important for calculating when an employee must be paid this overtime. And that overtime pay has to go on to whatever the paycheck is that applies for the work week in which the overtime is paid. So what that means is if your employer pays you bi-weekly every 2 weeks and you work overtime in week 1, whatever overtime you worked for that pay period has to go into that paycheck that includes week 1 and week 2 of that pay period, right? What the employer cannot do is have you work, say, overtime the first week of January and then not pay you that overtime until the end of the first calendar quarter ends. Like, they can't hold that overtime and pay it out at the end of March. And sometimes employers try to do that as a way of balancing their wages and that expense against the flow of business or the flow of revenue to the company. And if you're a company that has a large amount of unpaid bills, your payroll practices can be a problem trying to make sure that there's enough cash flow to cover everything. Well, the problem is it's not your employee's burden to help you figure out how to pay your bills or how to get your customers to pay you. If the work was done, it's got to be paid, and it's got to be paid in the pay period in which it accrued. And that's really all there is to it. There's no exception. There's no wiggle room. Employers can't make a backroom deal with the employees to pay them overtime down the road, even if they're willing to pay interest on the amount. It's just got to be paid in the pay period in which it's accrued. So we've already identified a number of ways in which employers try to get away from paying overtime when it's due. One other issue that I would point out is that employers often try to avoid paying overtime as a whole purely by misclassifying employees so they're not covered by the Fair Labor Standards Act and its overtime provisions. And there's two ways that employers commonly misclassify employees. One is by misclassifying employees as exempt under the Fair Labor Standards Act by paying them a salary but then treating them like hourly employees, which destroys the exemption, or by paying them a salary although they do not meet any of the other tests under the salary exemption under the Fair Labor Standards Act. And that's another long issue that will get its own video at a later time, but just know that that's an issue out there. The other way that employers commonly misclassify employees is by classifying them as independent contractors and then proceeding to treat them as employees. Independent contractors are not covered by the Fair Labor Standards Act. They're covered by contract law and whatever the terms of the contract happens to be. That's a way that employers get away from paying a lot of the cost of maintaining employees in their own internal staff. And of course, part of that is avoiding paying overtime pay to those employees, or to the contractors. But if you are actually an employee, the way that the Fair Labor Standards Act determines what an employee is, the way the Department of Labor calculates it, then you are entitled to overtime pay and minimum wage if you're not being paid minimum wage for your work. And that can build up to a substantial sum of money that an employee is owed purely because the employer miscalculated them as a contractor and failed to pay proper wages. If for any reason your employer is miscalculating your benefits, your overtime pay, if they're not paying you for the work that's being done and you are entitled to overtime pay, you definitely have some remedies available to you. You can, of course, recover the wages that you should have been paid. You can also recover under the Fair Labor Standards Act liquidated damages, which doubles the amount of unpaid wages that you're owed. You can also recover attorney fees and court costs and interest so that you can actually be made whole for whatever it cost for you to get into court and have a battle over getting paid for the work that you've already performed. So if you feel like your employer is not paying you overtime and you should be entitled to this pay, best thing I can recommend for anybody is to talk to an employment lawyer who deals with overtime pay issues and let that attorney review the situation, review the employer's practices, and identify if you should be paid overtime pay and what's going to be the best course of action to both protect your job so that you can continue to have a paycheck, but then also try to get these unpaid wages recovered for you, as well as these other damages that you can recover. It's worth pointing out that under the Fair Labor Standards Act, there is a statute of limitations to how far back unpaid wages can be recovered. And if this is a problem that's gone on for a while, each pay period that goes by is a pay period that's dropping off the statute of limitations. So it's important that if this problem has gone on for a while, that you talk to an employment attorney as soon as possible. But that's pretty much it for this video. There's some issues that we've talked about, the issue with the salary exemption, and some other issues with the FLSA that will merit their own videos, and I'll talk about those issues more in depth. So if you're looking for more information about overtime pay or salary exemptions, that will be out there, but those will be a little longer videos than what these are, so it'll take some time to put that together and try to make some sense out of it. But eventually I plan on getting those out there onto this channel. If you've got some more questions in the meantime, there is some more information about these issues on my website. There's links below, as well as into my blog where I talk about a lot of these issues as well. If you find that information useful, that's great. Keep in mind, of course, that I only practice in Texas, and so I'm writing from the perspective of what Texas law is. If you're in a different state, your state laws may give you some additional protections that we don't have in Texas, or additional enforcement mechanisms that we don't have in Texas, and that's something to explore with an attorney in your own state. So that's pretty much it for this video. Thanks for listening. I hope it was helpful, and I'll see you next time. Thanks.